Yes, good evening to everybody. Welcome to the today class of the Muslim law. And I already posted yesterday that I am going to deal today the divorce that is called talaq. In other words, yes. If you happen to see that what I posted on the screen, please unmute and read what is posted on the screen. Hurry up, anyone. Hurry up. Anyone can unmute and read what I posted on the screen. Speak.
Classification of dissolution of marriages.
Good.
Dissolution of marriage by act of God, death of husband or wife. By act of parties, divorce. Extrajudicial divorce, judicial divorce by wife under the Dissolution of Muslim Marriages Act 1939. In extrajudicial divorce by husband, by wife, by mutual agreement. By husband, talaq, ila, jihar. By wife, delegated, talaq. By mutual agreement, kula, mubarat.
Professor Dr. M.S. Hussain. So that is the today's thing which I want to share with you. Then let us come to the law, that is the Muslim law. Let us deal the introduction, classification of the dissolution of marriage, that is the kinds of the divorce under the Act 1939, talaq nama, talaq made during the death illness, legal effect of talaq, or the divorce or conclusion. This is the scheme which I want to make it out. But in our syllabus also, yes, I will show you the syllabus so that you could know it, what is written over there. Yes, syllabus also it is given in the same manner, yes. In the syllabus, unit 2, divorce, classification of divorce, different modes of talaq, legal consequences of divorce, and dissolution of Muslim Marriage Act of 1939. So this is the as per the syllabus which I made. But yes, let us come to the point of our study, talaq under the Muslim law. And when you say the talaq, for understanding the method of the dissolution of marriage, let us first see what marriage is under the Muslim law, because the only essential for the divorce under the Muslim law is marriage. See, you cannot take the divorce when the marriage is not a valid marriage. Am I right? Am I right?
Yes, sir.
You cannot unlock the lock unless it is locked. In the divorce, also the same thing. You cannot go for the divorce when there is a marriage, is a valid marriage. So the dissolution of marriage is known as divorce according to the Dissolution of Muslim Marriage Act of 1939. Instead of saying the divorce and talaq after the enactment of this act, that is the dissolution of the Muslim Marriage Act of 1939, we say the dissolution of different kinds of dissolution of marriage. And talaq as per the personal law of Muslim. Sir, divorce and talaq both are the same, sir? Anyone? Anyone? If you don't know, you say pass on. Yes? Whether the divorce and talaq both are the same. If you know it, you tell me. If you don't know it, you say pass on.
Pass on, sir.
Why you are taking that much time to say the pass on? See, we have seen the chart. In the chart, it is clearly mentioned. Judicially, it is went over there. That is called dissolution or divorce. But extrajudicial divorce means personal law is concerned, we say talaq. See here, extrajudicial divorce, which is nothing but the personal law, where we can say talaq, that is by husband, by wife, by mutual agreement. And here we say talaq, ila and jihar. So personal law say it is a talaq, and judicial way that we can say it is a divorce. So that is a point of distinction between the two. So there is but generally personal law we say talaq, but we use these two terms interchangeably now and then in our classes or in our lecture. Talaq is Arabic word which means freeing or undoing the knot. Talaq is a Arabic word which means, yes, read, which means, yes, which means, please read anyone.
freeing or undoing the knot.
Yes, that is the equivalent of English. So under the Muslim law, marriage is a contractual relationship between the two parties. Of course, we can also say that it is a sacrosanct also. All the essentials that are required for the contract are present under the Muslim marriage. Yes, whatever the contract things would be there, it will be present under the Muslim marriage also, like the capacity and the age of the party, status, or mental, what is insanity, or sane mind, all the things are there. There is an offer, acceptance, consent, consideration, the capacity of the parties, etc. The purpose of such a form of marriage is legalizing the sexual intercourse for procreation of the children. Why one will marry? If anybody will ask, what is your answer? What is your answer? Sir, we don't know, sir. Sir, we are not married, sir. Your answer is, it is a license for the legalizing the sexual intercourse, that is the BBC, for what? Procreation of the children. Sir, if there is no children, sir, what will happen? That is a different issue again. So in the case of the Shoharat Singh versus Jafri Begum, that is the case law, the Privy Council held that marriage under the Muslim law is a religious ceremony. Under Islam, marriage is recognized as a basis of society. Marriage is an institution which leads to upliftment of man and is also a means of continuance of the human race. Suppose, suppose if there is no bond of the marriage, what will happen? Like we are an animal being that we will behave like nobody will care knows. Are you following me? Marriage is an institution which leads to the upliftment of a man and is also a means for the continuance of the human race. So that's why the marriage should be there. Suppose we will not be coming to the existence, suppose of our parents are not married each other. So divorce is the end of such a marital relationship. So the end of the marital relationship is divorce. As under the Muslim law, there are two modes given for the dissolution of marriage. That the divorce or the talaq. The Arabic word for the divorce is a talaq, which means freeing or undoing the knot. So that is the meaning under the Arabic language talaq. In daily life, these two terms are alternatively used just before I read it. And talaq proceedings are governed by the Muslim personal law. That is extrajudicial. Otherwise, we can say, in other words, we can say it is a personal law. So the chart which I have shown you is a little different from this chart. So classification of the dissolution of marriage, where the two arrows are given, the left hand side, the death of the party, on the right hand side, big divorce. Then the divorce will be again divided into the four. What are the four? Anyone can unmute and read. The divorce will be divided into the four. What are the four? Anyone can unmute and read.
Kula Mubarat by judicial decree under the Dissolution of Muslim Marriage Act 1939, Lian and Fas.
Yes, I said by divorce there are four are divided. The number one by the husband, number two by the wife, number three by mutual consent, number four by judicial divorce under the Dissolution of Marriage, Muslim Marriage Act of 1939. Again, when you come to the by husband, three types are there. One, talaq, two, ila, three, jihad. And come to the matter of the wife, wife is mutual agreement of the talaq is called talaqil tafwiz. That is called talaqil tafwiz. By mutual consent, there are two types of their kula, mostly is moved from the wife side, mubarat, generally moved from the husband side, and both the side also it can be moved. And by the judicial decree under the Resolution of Muslim Marriage Act of 1939, they have given at least 9 grounds to take the divorce. And in another form also, the Leon also included over there, and the Fusk also included under it. When you come to the matter of the talaq is concerned, again, talaq is divided into, read anyone? Talaq is divided into, unmute and read.
Talaq ul sunat, talaq ul bidat.
Good.
In talaq ul sunat, Hasan, Hasan.
Good.
In talaq ul bidat, return talaq, triple talaq.
Yes. Again, the talaq is divided into the two categories. One is the talaqul sunnat and another is talaqul biddat. And in the talaqul sunnat is divided again the ahsan and the second is hasan. And the talaqul biddat is divided into two. Number one is the written talaq and the two is the triple talaq. Now I want to test your memory. What is that case law where the Supreme Court has decided that triple talaq is against Article 14, against Article 19, against Article 21, against Article 25 of the Indian Constitution? Now you tell me, what is the case law? Yes? I told you already, if you don't know, don't waste the time. What do you have to say? Pass on.
Fasan, sir.
Sayaro Bano versus Union of India. Sayaro, Sayaro, space Bano, Bano, versus Union of India is the case law where the triple talaq is unconstitutional. So now let us see that now how the personal law is concerned and by husband, what are the things will comes over there. There are four modes of the available before a husband for dissolving the tie of the marriage. Number one, talaqul sunnat. That what it means. This form of talaq is effective in accordance with the tradition established by the Prophet. It is further divided into the two parts. One is ahsan, another is hasan. Then what is ahsan? Ahsan. The ahsan talaq consists of a single pronouncement of the divorce made in the period of a tur, that is the purity between the two menstruation cycle, or at any time. If the wife is free from the menstruation, followed by the abstinence from the sexual intercourse during the period of the iddat. But only the one thing that I would like to make it out, because Talaq, I am even myself also should not pronounce in so many ways, so many times. Because whenever the word will come, no, we will say Talaq or Talaq, but generally Talaq will be pronounced only once, that is the first tour period, up to the iddat period. Iddat period consisting of how many months? Anyone? Answer. Iddat period consisting of how many months?
2 months, sir.
Including 3 months total menstruation cycle. 3 months, lunar months or solar months. If you don't know, you say pass on. Don't waste the time.
Pass, sir.
It is 3 lunar months, not solar months. So, the first menstruation cycle, Tuhur period, when 1 month, he should say Talaq only once, and there is no sexual intercourse, abstinence. Second month, menstruation cycle, Tuhur period, but no utterance of Talaq, no utterance. Only first time, Tuhur, only utterance. Then no continuance of the sexual intercourse, means abstinence from the consummation. In the third month, Tuhur period, no consummation, abstinence from the sexual intercourse, but after the iddat period is over, it become irrevocable. So, Prophet Muhammad said, the word Talaq should not be taken on your word, on your tongue. That's why that word try to avoid it. Only last resort where there is no reconciliation, then he encouraged Talaq. under the personal law. So in the 3 months, only one time, the first time TALAQ will be said, but the second time Tuhur no, third time Tuhur no, only abstinence from the conjugal rights. That is the no consummation, no BBC. So that is called ahsan. So ahsan is the best form of the giving the talaq, because the bad word, the sin word, TALAQ, should not be on your tongue. That is the point. So that is given. So the same thing which is given over here, it is known as the best form of talaq, as the name clarifies the same. The procedure followed by the husband is as follows. He has to make a pronouncement of the TALAQ in a single sentence. Such a pronouncement must be made in purity state when a woman is free from her menstruation cycle. Number second bullet, a husband must not indulge in any form of BBC during the iddat period. The period of chastity of a Muslim woman is bound to observe after the judicial marriage, either by the death of her husband or by the divorce. If he does so, then it will be considered as the implied revocation of talaq. That is the TLAQ. If there is a consummation would be there in the span of the period, then automatically it will no talaq. TALAQ will be revoked. It is a pertinent to note that once the iddat period was expired, the divorce become irrevocable. Means the 3 months are over and no consummation, no BBC. Only one time uttered at the purity time, it is enough, then it becomes irrevocable. The last point it says is when the partners have not consummated, I told you that no BBC, that is a talaq al-ahsan, can be pronounced even if the wife is in her menstrual cycle. So once there is abstinence should be there, and 3 periods are over, Nitur periods are over, only one time uttered, TALAQ, that is the first purity time, then it automatically become irrevocable because there is no consummation or there is no BBC, there is no body to body contact. So a Hassan, AHSAN. Now let us see the Hassan, HASAN. Only the difference between Hassan and Hassan is the word TALAQ is pronounced in the first Tuhur period. The word again pronounced TALAQ in the second Tuhur period. The word TALAQ is pronounced in the third Tuhur period. Means he has to utter the sinful word 3 times on his tongue, through his tongue, from his mouth. So that is only the difference you will feel it between the Ahsan and Hassan. The reason is there may be a possibility that it will be revoked after the first Tuhur period is over. There may be a possibility that it will be revoked after the third purity period. So that is the reason they say the sin word will not be uttered through the one's mouth. So first time only uttered in the Ahsan, AHSAN, and the 3 times the sinful word is uttered by the husband in the 3 Tuhur periods, it is a HASAN. That is only the difference we will find it. I believe that it's clear to you. If any doubt would be there, you can ask me. Any doubt? Shall I proceed?
Yes, sir, proceed.
Very good. I appreciate. The same thing, in short, the Arabic meaning of the Hassan is a good. Therefore, divorce pronounces through the Hassan mode is a good, but lesser worth than the one pronounced in the Hassan, because in Hassan only one time TALAQ is there, but in Hassan 3 times TALAQ is there in the third period. Husband has to make the 3 successive pronouncement for divorce. That is TALAQ. In the case of the menstruation wife, which 3 pronouncements should be made in 3 consecutive tours, that is the state of purity, and every month one pronouncement, second month tour, another pronouncement, third month, another pronouncement, that is the TALAQ in the Tuhar period. The second word says that in the case of the non-menstruating wife, suppose the menstruation is not that, means a woman who is not menstruated is also known as she went to the menopause. The menopause is there at the time, they will count it only 3 successive intervals of the 30 days. That is in the 3 lunar months they will consider. Means 3 lunar months is equal to 90 days. Should be made at 3 successive intervals of the 30 days each. 30, 30, 30, 90. So no sexual intercourse, no BBC, no consummation should be take place during the period of 3 pronouncement. If such a act takes place, the process of divorce, the TLAQ, if any consummation is happened in the span of 3 months, then automatically TLAQ is revoked. So Talaq Hassan becomes irrevocable on the third pronouncement, irrespective of that period. So once the third period is over, even though the woman is going to the menstruation cycle also, once the that period is over, I mean, third period is over, automatically it becomes irrevocable. So that is called. So next is the point is talaqul biddat. Biddat means sinful. This form of talaq is introduced by Umayyads. Actually, there is no such a in the prophet period. It is not there. Talaqul biddat is not there. That is called written talaq, or the triple talaq was not there. But in the Umayyad dynasty is there at the time. In order to escape from the strictness of law, this is sinful from the talaq and is recognized the Hanafi school. Only Hanafi school, that is the Sunni school, recognize this talaqul biddat. Otherwise, in other schools, there is no such a thing. So, whereas the Shia and Maliki, they don't recognize this mode. Actually, why this has come into the picture, I will give the reason. This has come into the picture because the Muslim dynasty is what I say. They conquered the other countries like Syria, Morocco, Egypt, and they conquered it. When they conquered these countries, and where the men will be killed and the women will be left over there, and especially Syria women and these Egyptian women are so beautiful, and they are very much tempted by looking them. So they will become orphans or widows, and they will be on the roads. That is the reason that what they said is they divorced one of the wife and they married the beautiful woman of the Egypt or the Syria and the Morocco people, so that they could give the livelihood to them. So that was actually the thing which is happened over there. So they divorced one of the wife and they married the beautiful woman, and whose husbands were, yes, whose husbands were, please fill up the blank, whose husbands were killed in the war, in the conquering. Did you get my point?
Okay, sir.
Say yes. Whose husbands were killed in the war in when conquering the place, and that is the reason they have married that. So the three pronouncement made in a single tohar, either in a single sentence or the single way, TLAQ, TLAQ, TLAQ enough, or DIVORC, a DIVORC, DIVORC is enough. In a single pronouncement, either written form or uttering the 3 times at a time in a one breath, also they recognized. And the partners separated the triple talaq can't remarry without the formality of the woman marrying another man, getting divorced from him. This process is called nikah halal. And I am sure that you might have seen the nikah movie. Once you give the TALAQ to a woman, again the same woman you cannot marry. If you want to marry the same woman, again you have to go the process, because that woman should have to marry another man, and there would be a sexual intercourse, the consummation must be taken place, and later on she can take the divorce. Then if that period should be completed, after that only she can be married to that man to whom that a man has divorced her. So that is called a process should be completed over there to make that woman halal. So that is the point which I want to make it out. Then Bhaskar Tirupati, you are welcome to the class. Anyway, then a single declaration, that is the procedure is there, and the husband may make only one declaration in the period of the purity, expressing the intention to divorce the wife, irrevocably saying the I divorce or divorce irrevocably, or 3 times at a point if you say, or one time also say, either written or oral, it will be made. Again, the triple talaq, I made it very much clearer. In a one breath, he say TALAQ, TALAQ, TALAQ. So that is the way. Now, the Supreme Court has made that Sayara Bano, SHA. Of course, some people write SHA, some people write SCA. SHA, Sayara. SHAYARA space BANO, Bano versus Union of India. This is the case law of the 2017, that is the ninth volume on Supreme Court cases, page number 1. This case law is clearly mentioned. This case law clearly says that the triple talaq is within the meaning of the expression law in force. It is against to the Article 14, Article 13, Clause Subarticle 1 must be struck down, being the void to extent that it is recognized the enforce the triple talaq is unconstitutional. So subsequently, the government of India has passed a law banning the triple talaq and punishing the any husband who pronounced the triple talaq with imprisonment up to 3 years. So there would be a amendment also made after this 2017. If any person made such a thing and which is banned, which is said to be the biddat by the Prophet Muhammad himself, but the Supreme Court also, they said it is unconstitutional, triple talaq, and if any person did so, he will be criminalized and the punishment up to the 3 years. Yes? Is it clear? Is it clear?
Yes, sir.
Bhaskar Tirupati. Sir, I just joined only now, sir, because I don't know what you taught, sir. Okay, can you tell me,
Yes, sir.
Bhaskar Tirupati?
Sir,
Unmute
sir,
and tell
sir.
me.
Good evening, sir. Good evening, sir. I have
Good
lately joined.
evening. Yes, Tirupati Garu, what I am teaching now?
Sir, sir. Triple talak, sir.
Yes, I appreciate. What is the case where the triple talaq is unconstitutional?
Saira Banu versus Union of India.
I appreciate. Sayara Banan versus Union of India, that case law that will make it out very much clear.
Saira Banu
And
versus Union of India.
yes, I appreciate. Good. Then one of the mode is ila. Ila means vow of continence. Means besides talaq, a Muslim husband can repudiate his marriage by two other modes. There are ila and zihar also. Of course, it is not in a practice in India. They are called the constructive divorce. In ila, ila, the husband takes an oath. What oath? Not to have BBC with his wife. What the husband will do? The husband will take an oath not to have BBC. Sorry, what is, sir? British Board Corporation, sir? Body to body contact. So, in another terms, instead of saying every time sexual intercourse, that's why I made the acronym BBC. That the body to body contact, no, with his wife, and followed by his death, and followed by this oath, there is no consummation for the period of the 4 months. If he takes a oath, it is also a lead to the ila, that the vow of conduct. Yes, you are speaking yourself, because if you speak, I could hear your voice. I know that what you are also speaking, I could hear. After the expiry of the 4th month, the marriage dissolves irrevocably. But if the husband resumes the BBC within the 4 months, then automatically it will be revoked. So ila is a cancel and the marriage does not dissolve. And the marriage does not dissolve because there is a consummation is there. Under Itna Sharia law, that is the Shia school, ila does not operate as a divorce. Of course, only the Sunni law will recognize. Of course, it is not more in a practice now, without the order of the court of law. After the expiry of the 4th month, the wife is simply entitled for a judicial divorce. If she wants, she can take the judicial divorce. Of course, that is a ground for the even take the divorce under the what I say Dissolution of Muslim Marriage Act also. If there is no cohabitation, even after the expiry of the 4 months, the wife may file a suit for the restitution of conjugal rights against the husband. If there is no such a thing would be there. Of course, if the conjugal rights are resumed over there, then the ila will be revoked. Of course, this is not in a practice now, because nobody will take the oath that I don't have the BBC with my own wife for the 4 months. Unless until there is a vested interest would be there. Next, jihar. This is the injurious assimilation. So what is the injurious assimilation? A husband must be of sound mind, number 1, and above the age of 18 years, number 2, be eligible to use the mode of dissolution of marriage, number 3, if he compares his wife to his mother. See, nobody would compare the wife as a mother. Sir, wife can also play a role of a mother. Okay, playing a role is different, comparing or making the mother. Can you call your wife as a amma manchukunnava amma? You don't say like that. Sir, with the love of action, we can also say that no, better to say wife only. Or you better say, instead of saying amma, you can say, my oxygen, how are you? You can say. Are you following me? Are you
Yes,
following
sir.
me?
Yes, sir.
Then what do you have to say if your love and affection is more? Yes? If the love and affection is more, what should you have to say? The husband to the wife. Say, pass on, I will give the answer. Yes?
Pass, sir. Oxygen.
You can say my honey, my baby, my what I say, moon, my Rosie. You can use any word, but don't say Amma. Are you following me? Say yes.
Yes, sir. Yes.
I appreciate. So don't make this his mother any of these female within the prohibited degree, akka, amma, chelle. How could you say so, your wife? The wife has a right to refuse to have a sexual intercourse with him if he utters such a word. Such a refusal can be accepted until he has expiated himself from the penance prescribed by law. If he does so, then the expiation would be there. Either he has to fast for the 2 months, or he has to feed the six hungry man, or 60, not six, 60 hungry man, or 60 people, he has to give the food. Annadanam. Releasing one slave, or at the time slavery was there, either you release one slave to expiate them if he does so. So that is the thing where you can come to the normalcy. That is the penance. Perform the penance or pronounce the regular, that is way. Muta marriages, of that is the practice only in the Shiala, which is the time-bound marriages are there, which admits no other sort of the divorce may be dissolved. So there is no jihar and such a muta marriages, and the divorce is no longer the use in anymore, because the muta marriages are time-bound marriages. Okay, we will marry each other for 3 months. Okay, 1 year, 2 year, 3 year. Later on, okay, with the children are there, then I will take care of them. And the wife would be there, he will give us something for her livelihood. Suppose if he doesn't have the more than 4, then he will take that wife and make it permanently to be one of the wife. So that was the practice would be there at the time, because men are more and women are less. Talaq by wife, let us see how the talaq by wife will there. Then TLAQ of by wife. The divorce given by the wife under the husband delegated power means husband says, okay, you'll be permitted to give the talaq. That is called talaq tafwiz. That is called a husband delegates such a power to whom? A husband delegates such a power to whom? Yes.
Wife.
Wife, why you are taking that much time? Okay, such a delegation is called talaq al-tafwiz. This is the only way through which a woman can give divorce to his husband. However, such a power given divorce needs to be delegated by the husband only. It is the form of an agreement made either before or after the marriage, providing the wife will be privileged to get separated from her husband, where divorce under the specified condition has. What are the conditions should be there? Number 1, in case the husband marries a second wife, okay, this will be khula. That is the tafal tafiz, delegated legislation. He will take the relief, talaq, from the husband. Number 2, the husband is unable to maintain her for a specified period of time any other condition that must not be opposed to the public policy. In such a cases, the wife will ask and the husband delegate such a power, and that is called talaq tafiz, where a woman can move. If the condition agreed in the agreement by the husband as well as the practice by him, when the wife without any prejudice the law and dissolve the marital ties. Yes, at the time the wife can dissolve the marital ties because the permission is given or delegated power is given by the husband to the wife. The fact that the husband delegates the power to the wife does not dispose him of his right to pronounce the law. Suppose if it is delegated, it doesn't mean that he has lost the right to give the TALAQ. So one of the cases like that is Muhammad Khan versus Shahmai. Under the prenuptial agreement, the husband who was a Khana Damad. Khana Damad means Illarikam. Undertook to pay certain amount of the marriage expenses incurred by the father-in-law in the event of his leaving the house, and conferred a power by the pronounce the divorce on his wife. The husband left his father-in-law house without the paying the amount. The wife exercised the right of the divorce herself. It was held that it was a valid divorce because the condition is that he should be a illarikam dama, alludu. Suppose if you violate it, then the wife is having the every power to divorce such a man. So that is the condition already put it in writing before the marriage. So delegation of power may be made even in the post-marriage agreement. Thus, where under the agreement it is stipulated that the event of the husband failing to pay her maintenance or taking the second wife, suppose kharche pandan, kharche mewahori, if it is failed to provide to the wife, then also that is a violation. Then the wife is having the power to give the divorce to the husband and will have the right to pronouncement divorce on herself. Such an agreement is valid, yes, before the marriage or after the marriage also. And such conditions are reasonable and not against the public policy. Yes, that condition are very much reasonable because they agreed in advance that you are supposed to give kharche pandan, number one. Number two, kharche mewahori, number two. Number three, suppose if you are going for the second marriage or another woman you are going to marry it, then automatically that you are giving the power to give you divorce. That condition is already put it over there. So it should be noted that even in the event of the contingency, whether or not the power to be exercised, depend upon the wife, she may choose to exercise it or she may not. Suppose if he wants, she can exercise. If she doesn't want, okay, let him enjoy it, what they, because he's taking care of me well, and he's not overlooking me. Even though he will give the equal respect to me, let him enjoy that she's also a woman like my sister. Can a woman think so? Anyone? Can a woman think so? Sir, we don't know, sir. Tirupati garu,
Sir, చెప్పండి చెప్పండి.
can a woman think so?
No, sir.
No woman wants that her husband will share with some other woman. Are you following me?
Yes, sir. Follow me, sir. Following.
I appreciate. The happening of the event of the contingency does not result in that is the automatic divorce. Yes. Now, divorce by mutual consent. We studied divorce by husband. We studied divorce by wife. And the third type of is divorce by mutual consent. Although the practice even the divorce by the mutual consent was not recognized in the Muslim law. Earlier, there is no such a mutual divorce. But after the amendment is made with the Dissolution of Marriage Act of 1939, then one can. It was only available to the Muslim women after the enactment of the Dissolution of Marriage Act of 1939. That is number one, khula. And the literal meaning of the khula is to lay down before the law. Okay, now you are free. The husband lays down his right over his wife. Okay, now I am giving you, okay, you can go for it. Signify an agreement entered into the dissolve connubial connections. Okay, no more now sexual intercourse, no BBC, no nothing, no consummation. Now you are free, you can leave now. But in lieu of the compensation paid by the wife to her husband, I will free you provided that you have to pay some amount to me. And the property, everything that can be given as a dower. Whatever the dower which I have given you, you have to return me, plus with interest, then I will give the permission. Okay, now you can be free. That is called khula. And khula is moved from the wife's side by giving some consideration to the husband. Yeah, khula is a divorce with a mutual consent at the instance of the wife, but the initiative is to be made by the wife, in which she agrees to give some consideration to her husband. It is basically redemption of the contract of marriage. It is nothing but the redemption, because some consideration will be paid by the wife, whatever the amount which is given her in the form of the dower. Yes, that amount will be returned with its interest. At that time, the husband says, you are free. So that term of the freeness given is a called khula. Means it is a type of the divorce in the personal law. What are the essential things? There must be an offer from the wife's side. Yes, the wife should have to make an offer. To whom? To the husband. Number two, offer must be accepted by the husband. The husband should have to accept such an offer with the consideration for it, not without the consideration. With the consideration for it means something should be given in the return by the wife to the husband. And the third condition is that observance of the iddat period is necessary. Yes, they have to wait up to the iddat period, that is the 3 lunar months. Under the Shia law, the husband cannot revoke the divorce once accepted, where the wife has been given the power to reclaim the consideration during the death period. Of course, some conditions are put it over there, when one can revoke, when one cannot revoke it. After the expiry of the 4th month of the wife has the following right. Yes, no consummation, And expiry of the 3 months and the expiry of the 4th month, yes, everything will be finally settled. She may go to the court to get the decree divorced. Yes, she can go to the court to get it stamped. That is a judicial divorce, or it is a permanent divorce, and she may ask the court to grant the decree of the restitution of conjugal right. In case if it is not, there is a consummation is there, and consummation is there, or if she doesn't want to take it out, then she can ask for the conjugal rights also. So where the husband wants to revoke the jihar by resuming the cohabiting with the set period, the wife can seek the judicial divorce. It can be revoked. Of course, when there is a in the period of the iddat, if there is a consummation is there, automatically it will be revoked. So the husband observes the fast for the period of 2 months, and he provides the food for the 60 people if it is a ziyar, and he frees a one slave. That is the way one can have to stop it. So the second one is mubarat. In mubarat, generally what will happen is the mutual discharge from the marital tie. The most essential element is that mutual consent of both the parties are required in regards to the civil of marriage. It is not moved from the wife. In the khula, it is moved from the wife. But in the mubarat, it is moved from the both the sides. Both the sides that would like to take the TALAQ in the personal law. So in this mode of divorce, number one, offer can be made by either of the sides. Even the husband can make an offer, or the wife can make an offer, or both can be making an offer. To what? To get a divorce, TALAQ. And acceptance of the offer makes the divorce irrevocable. Suppose if they agree together, then automatically it will be revoked. Of course, provided that 3 iddat period, not 3 iddat period. Iddat period should be completed over there, and the 4th will be completed, then automatically it become irrevocable. So iddat is necessary. Okay, I will ask you one question, and I'm sure that your lecturer taught you. In case the death of the husband, how much the iddat period? Anyone? Suppose if you don't know, you say pass on. I will give the answer. Yes? Did you understand the question? Did you understand the question?
Yes, sir.
Give me the
Yes, sir.
answer.
Don't know, sir.
Okay, I will give the answer. Hey, no, personal talk. Mute. I will give the answer. In case of the death of the husband, the iddat period is 4 months, 10 days. Is it clear? Say yes.
Yes, sir.
Suppose the woman is no menstrual cycle, menopause. How much period the iddat period? If you know, you tell me. If you don't know, say pass on. Don't waste the time. 3 lunar months. That means each month consisting of 30 days. 30 plus 30 plus 30, 90 days. Okay. If a woman is pregnant, whatever is that period? If you know it, you can tell me. If you don't know it, say pass on. I repeat, if you know it, you tell me. If you don't know it, you say pass on. I will come to your rescue.
Don't know.
Till she delivers a baby. Okay. Under the Shia, the parties can dissolve their marriage if it is not possible for them to continue their marriage by way of Mubarak. So they said, the last resort, okay, the life will become miserable. Better we will take the divorce. You can live your life comfortably. I can live my life comfortably. So that is the Mubarak, the mutual consent given by each other. The last mode of mention in the above table of the resolution of marriage by way of the judicial separation. So now, the dissolution of marriage, still we have the 5 minutes in our hand. Dissolution of Marriage Act 1939, and there are many other things comes like Lian is there, and there are several grounds are put it over there for getting the divorce. And we already studied what are the grounds where a woman can approach to the court for the dissolution of marriage. Can anybody will give at least 1 or 2 grounds I would like to know from you. Yes? I already told you, if you don't know, you can say, sir, pass on. I will give the answer. There is no answer from your side. What are the grounds where a woman can ask for the divorce under the Dissolution of Marriage Act? There are 8 to 9 grounds are there where a woman can approach to the court. Shravanti, unmute and give me the answer. Sir, I don't know. Please say the same thing. The same you can say. Shravanti, unmute. Sir, I don't know how to unmute it. And Soumya, of course, Shai Rishita is very much expert in the muting and unmuting. Chandra Prakash Reddy. Sir, we don't know how to unmute. Don't worry, okay, because I don't teach the class like a preacher will give the preach and you are just here, and one way, it is called one-way traffic, that is. So one-way traffic is not a good way to teach. Okay, we'll deal it in detail, but meanwhile, when you come to class tomorrow, please read what are the grounds where, and it is given in the section 2, A, B, C, D, E, F. As far my knowledge goes over there are 8 to 9 grounds are there where a woman can approach to the court for getting the dissolution of marriage. So under the Act of 1939, that is the Muslim Women Dissolution of Muslim Marriage Act. Of course, here I say, let me finish the Lian, then I will go further. Lian can is simply described as a wrong charge of adultery. Suppose if you make an allegation on the wife that she has committed adultery over there, if it is not proved, then the wife is having the ground to go to the court and file a case against the husband to get the divorce. So that is the charge. If the wife can sue him and also obtain a divorce on the same ground under the Act by filing a regular suit of the dissolution of marriage, in case of the Jafar Hussain versus Ummat-ur-Rahman, Allahabad High Court held that the wife under the Muslim law is entitled to file a suit against her husband for dissolution of marriage and can obtain the decree on the ground that she was falsely charged with adultery by him. So that is the Leon, and where the condition, a husband must be adult, and the same second bullet is he charges his wife of adultery. Third is such a charge must be false, and the fourth is false charges don't ipso facto dissolve the marriage. It just provides the ground for the wife to move to the court to dissolve the marriage. Number 4, marriage will continue until the degree of the dissolution of marriage is passed by the court. And the next point is judicial separation by a mode of Ilian is irrevocable. This mode of the applicable by the Sahih marriage means it is a valid marriage. Sahih marriage means valid marriage, not fasid marriage, that is the irregular marriage. And whereas the wife hurts the feeling of her husband with her behavior on the husband, hits back on the allegation of the infidelity against her, that with the husband says there no response to the bad behavior of the wife and cannot be used by the wife as a false charge of the adultery, and no divorce is to be granted under the Leon. So when a false charges should be given over by the husband to the wife that she indulged in the adultery, at the time only it can be made. This was held in the case of the Nur Jahan versus Kazim Ali by the Calcutta High Court. But recently that a court, Supreme Court has given the judgment that a woman can have a BBC with the other man also, but it is not a criminalization. It is not a adultery. It is not a prostitution. But it will be a ground. If you want to give the divorce to her, you can give the divorce. If such a judgment will come in the Supreme Court, I don't know what will happen to the India, because India is the country which is having the civilized country and where our traditions are more important to us. And one man, one life, one wife. That is the policy of India. Otherwise, it will become a European country or the Western country where the people will introduce, please meet my 7th husband. The wife says to the other man, please meet my, yes,